Welcome, everyone. If you're getting ready for the Queensland bar exam, you already know that the Evidence Act has some real minefields. Today, we're going to do a deep dive into some of the trickiest, but most important, parts you have to know inside and out. We're talking about the procedural traps surrounding sensitive statements and the super powerful hearsay exceptions that can literally make or break your case.
Okay, here's what we're covering. First, we're going to carefully walk through what I call the Section 93A minefield. Then we'll get into the good stuff when you can actually get hearsay admitted, thanks to Section 93B. After that, we'll look at the safeguards, things like jury warnings and credibility challenges. And then we'll wrap it all up with the absolute key takeaways you've got to have locked in for exam day.
All right, first up, let's talk about the sections that have their own criminal penalties if you get them wrong. Yeah, you heard that right. We're talking about sections 93AA through AC. These are all about the super strict rules for handling pre-recorded statements, usually from vulnerable witnesses like kids. A slip-up here isn't just a mistake in court. It has serious, real-world consequences.
Now this is something you have to burn into your brain. Under Section 93AAA, just possessing a Section 93A statement or even a transcript of it without a lawful reason, well, that's a criminal offense. It's not about what you intended to do, it's just about having it. This is strict liability, and it's all about protecting those vulnerable witnesses. And believe me, the stakes are incredibly high. For you as an individual, you're looking at a maximum of 2 years in jail. For a corporation, the fines are absolutely massive. And these penalties, they apply to both having the document without permission under 93A and publishing it under 93AC. This is not a slap on the wrist. It is serious business. So what are your safe harbors? The Act isn't trying to make your job impossible, you know? It lays out very specific, lawful reasons for having these documents. The main one for us is for a legitimate purpose related to a legal case. The others are really specific, like for employment screening or when you're giving legal advice about that screening process. We'll touch on that next. And this is a perfect example of a classic exam question. Look at how careful this process is. The applicant, the person being screened, they never get the full transcript, just a summary. They're allowed to have that summary, and they can give it to you as their lawyer, specifically to get advice on that screening decision, and your use of it is then limited just to giving that advice. See, every single step is deliberate and tightly controlled. And then the Act goes even further with Section 93AC. This creates what is basically a total ban on publishing this material. And publish is defined so broadly, it's everything from TV and newspapers to, just posting it online. Want to get around it? You need the court's permission, and you'll only get that in exceptional circumstances, which, let me tell you, is an extremely high bar. Okay, so we've dealt with the strict procedural stuff. Let's shift gears now. We're moving away from rules and into a major exception to one of the biggest rules in all of evidence, the rule against hearsay. This is Section 93B. This is your go-to when your star witness is suddenly unavailable. Just picture it. The one person who made that critical statement, the only one who saw what happens, can't testify. This happens. It's a fundamental problem you will face. Before Section 93B came along, that evidence was probably just gone, lost forever. But this section, it gives you a powerful, though very specific, way to get that evidence in front of the court. But hold on. Before you even think about using it, you have to get through 2 gates. First, this only works in what are called prescribed criminal proceedings. We're talking the most serious stuff: homicide, serious assaults, sexual offenses, that sort of thing. And second, the witness has to be unavailable for a very specific reason. Either they've passed away or they're mentally or physically incapable of giving evidence. And even if you meet those 2 conditions, you're not done yet. The evidence itself has to pass through one of these 3 gateways to be admissible. Just one. Each one is basically a proxy for reliability, a reason to trust the statement even though you can't cross-examine the person. It's a crucial step. And if you want to know just how big a deal this section is, just read the commentary in Forbes, calling it a significant departure. That's putting it mildly. This section fundamentally changed the game for hearsay in Queensland. It moved us away from a rigid, old-school ban towards something much more focused on reliability, at least in serious criminal trials. So, of course, when you introduce a tool as powerful as Section 93B, you need to have some checks and balances in place, right? So the Act gives us 2 critical tools to make sure things stay fair. mandatory jury warnings under Section 93C, and a special way to challenge credibility under Section 94.
Now, if you find yourself on the receiving end of a Section 93B application, Section 93C is going to be your new best friend. If you ask for it, the judge must give the jury this three-part direction unless there's a really good reason not to. They have to warn them it might be unreliable, inform them why it might be unreliable, and then caution them to be really careful with it. It's a huge safeguard.
But what about actually challenging the evidence itself? I mean, the whole problem with hearsay is that you can't cross-examine the person who said it. Well, Section 94 answers that exact question. It gives you a toolkit that, in effect, lets you cross-examine a ghost.
Look, the text of Section 94 itself is pretty dense. The commentary calls it turgid, which is about right. But this table here boils it right down. It lets you introduce evidence you would have put to the witness if they were there. Things like, was this person biased? Or, with the court's permission, do they have prior convictions? Or didn't they say something completely different on another occasion? It really helps to level the playing field.
Okay, let's do a quick-fire recap for your study notes. Sections 93AA to AC, that's strict criminal liability for having or publishing these statements. You've got to know those exceptions cold. Section 93B, that's your three-gateway test for hearsay from an unavailable witness in serious criminal cases. Section 93C, that's your right to ask for a mandatory jury warning. And finally, Section 94, that's your special toolkit for attacking the credibility of that absent witness.
And that pretty much covers it. Look, you can memorize these rules for the exam, and you should. But the real challenge comes later, in practice. So the final thought I want to leave you with is this. It's one thing to know the law. It's another to apply it ethically. How are you going to balance using these powerful tactical tools with your absolute duty of fairness to the court? Answering that, well, that's what being a barrister is all about.